A very good morning and thank you so much for joining us right here on KBC Channel 1. It's 8:15. Welcome to a discussion that we should all be having this morning, the ICC aftermath, courtesy of what transpired at the International Criminal Court yesterday, some minutes after 6 p.m. Feel free to join into this discussion. 20511 is our SMS line. Begin with the initials GMK. You can also find me on Twitter at Sami1Njoroge, all Facebook. Samuel Njoroge is my page. I've got a panel of two gentlemen. Jared Okello, the gentleman who's nodding right now on your screen. Welcome to the program.
Thank you very much, and good morning to our viewers.
And to my immediate left, that is Dunstan Omari.
Pleasure to be on live, KBC TV.
And a pleasure to have the two of you.
Thank you very much.
Let's just start, gentlemen, by, getting your take on the ruling that was made by the ICC yesterday in as far as the no case to answer motion is concerned.
Well, thank you for the opportunity. Firstly, allow me to congratulate Deputy President William Ruto and his co-accused, Joshua Arap Sang, for the freedom that they earned yesterday. It's a huge step in their lives as individuals. It is a huge step for the Kenyan government because, of course, as you know, it did deny William Ruto a lot of concentration time to run this country. He plays a key role in the executive. So this is a gigantic step towards every Kenyan progress. Secondly, they have played into the hands of defense team's legal counsel, Karim Khan, who said right from the onset that the whole thing is laced on glaring and clear conspiracy of lies. And the judgment yesterday, to a greater extent, reflected that. In the month of February, when the Court of Appeal delivered a verdict on the usage of Rule 68 or application of Rule 68 in Ruto's case, that it could not be applied retroactively, you saw the pomp and celebration that accompanied that judgment and the ecstasy and joy that accompanied it. So you could definitely tell with certainty that that is where the evidence that could have taken this guy to the gallows or the evidence was. And therefore, that kind of celebration, I want to believe, really punctured the prosecution team. And you remember Bensouda said that it will now be a little difficult to prove beyond doubt any degree of culpability on what the two gentlemen did as regards the crime against humanity that the OTP presented before the judges.
Yes. So
to a larger degree, you could tell that having removed the 5 key witnesses, OTP remained with a very minute degree of evidence to stand trial at the point.
Omari, over to you. What's your take on the ruling yesterday?
First and foremost is that the ruling was long overdue. That ruling was supposed to have been done at the confirmation of the charges stages, 2011.
Pre-trial.
At the pre-trial stages, really there was no case that could have been sustained up to the end. So it was a delay on the Kenyan people. Two, the ruling makes a very fundamental issue. One, 2 officers, the office of the OTP, has totally failed to live to its expectations. One, the office of the OTP is funded by over 6 billion people worldwide. These were 6 billion people against 2 Kenyans. They have this enough resources. They had everything to do a credible job. So what comes up is that the 2 arms of the ICC, the prosecution side, which also controls the investigation side, has totally failed everybody. 2, the judicial part of the ICC, that is the judges, have lived to their expectations. Though, at once, when they allowed use of recanted evidence, everybody started seeing the ICC court as a banana court. But once that was corrected by the appeals chamber, when the courts have stood firm and followed the rule of the law and protected due process and also allowed the rights of the accused not to be trampled by virtue of some political clamor. Lastly, my take would be, when you look at this decision, one, where does it leave the civil society, especially the civil society in this country, that really clamored that William Ruto and Isaac Sang must face the music? So the civil society comes out totally wounded. Two, where does it leave the court brigade that was saying that Kenyatta and Ruto are supposed to be in jail? Those are people who are not supposed to be here. Those are war crime victims. Really, it brings a game, or a total game changer to the two, the people who are pushing for the conviction of the two gentlemen free. Lastly, when I look at this judgment, the decision is that there is two statements that every Kenyan should be worried about. That there was political meddling, there was political interference, there was a clear-cut political maneuver. And we are, I'm sure the judges always watch our programs on politics, and we've always told them that the ICC judges tuned to KBC are on politics. We told them very well clearly that, one, you cannot use evidence of a dead person. A cross-examination is the hallmark of every type of evidence that can be accepted. Two, we told them very well that really you cannot deal with an organized political machine that Uhuru Kenyatta has assembled. One, from the Kenyan political scenario. Two, from the Pan-African movement. Three, from marginalized countries, that is the Latino Americans, the Asian countries, and other states that felt that the war that was in the ICC was a war between the Western civilization, the Victorian regime, vis-a-vis the perceived third world countries. So when you look at that issue, you'll see the judges capturing it, that there was clear political meddling. Lastly, the ICC has made a dramatic decision that will save their jobs. Because one, there was a notion that they had to deliver heads. And the two heads they identified was William Ruto and Sang. But the judges have said, if Africa pulls out, if these other countries pulls out, we lose credibility.
We lose credibility. And bringing you, Okello, into that, no, a great membership of the Assembly of State Parties is drawn from Africa.
Yeah.
And ICC has had presence in Africa. Even it has tried, getting into some of these countries and prosecuting people to the logical conclusion. But here comes Kenya. In terms of profiling our country, is this finally the country, the African country that has punched some very serious holes into how the ICC works?
Well, Kenya has a great uniqueness, and that particular uniqueness has informed its strength to a greater extent. This is a country where an issue erupts and is being discussed across board, but then following week, another issue comes out and it trashes the other one. And, no one would have really expected that in the year 2013, 4 years down the line, having killed 1,300 people, majorly from two different communities, that these two communities could come together and vote one government and serve in one government. So that, Kenya is a little complicated nation. You look at how Uhuru Kenyatta, I would say, a new guy in the power sector of Africa, how he quickly managed to galvanize the entire continent and rallied the entire continent behind him. This was a personal problem, a personal challenge, as he did indicate during the presidential debate. But as soon assumption of power, he managed to firstly bring the ICC a government problem and made the entire continent have greater sympathy on him. Of course, anything ICC resonates very well with any African country because of potentiality to go through what we did go through in the year 2008, 2009. And I think it is on that premise, therefore, that Ocampo did say that Kenya is going to act as an example to the world. he knew that this can happen anywhere, particularly Africa. But if he was going to receive, or rather to win, a conviction for people from Kenya, then I think that was going to send a real signal to the international community. But as we said, you know, Kenya is a complicated nation. The other day, an international media house called this country a bed of what? Terror.
A hotbed.
A hotbed of terror.
Yes.
I don't hear that media house anymore. So you try to put Kenyans into a box, they box you out of it. But that diversity and uniqueness, I think, has also presented greater strength to us. Finally, again, on the issue of this ICC thing, the only thing now, it has put the trial back to the ICC by looking at the way they carry out investigations, because the judges were very clear that the evidence that has been adduced before them is not sufficient to move a case to the next stage. So you ask, was Ocampo just overjoyous over nothing when he mentioned that, you know, it will act as an example to the world? What was he looking at? Because you remember when the former UN Secretary General, Kofi Annan, presented whatever they called evidence and exhibits to him, there were tons and tons of documents. And we thought, well, you know, if you face this kind of evidence, you will be in jail forever. They were just hot air. Yeah, they were just hot air. Things that could not be able to make a case proceed. Out of 6 people who were presented before the ICC, they are now all out here. Yeah. Meaning that either 1,300 people never died or they just committed suicide. 650,000 people were not displaced from their homes, so they either voluntarily torched their homes or something unique happened. Yes. Then the question that therefore begs is, what therefore happens to the victims?
In fact, that is where I'm headed, but probably we misunderstood Ocampo when he said that he's going to make an example of Kenya. Probably we never totally got what example he was talking about. Yes. We leaned towards one kind of an example. We totally forgot this other. But now that Okello has brought in the issue of victims, let's deal with it once and for all. And I'm coming to you, Omari, with this question. How, as a country now, do we actually deal with the question of justice for the victims?
First and foremost is that the president has spoken, that the ICC gave the victims some false hope, that it will restore justice to them. All the state machinery went mum, waiting for the ICC to give justice. The president has given directions, and that directions are that it is time to address reparation issues. It's time to look for restorative justice. It's time to activate the Kenyan judicial system to deal with those issues. Remember, Sami, very well, is that the culprits at the ICC were presumed to be the people with the greatest responsibility. The people who lost their cows, the women who were raped, the people's houses who were burned. They know who burned them. They know who is sitting on the land. Yeah. Those matters are not international crimes. They are matters within the jurisdiction of the penal code and within the jurisdiction of the Kenyan criminal courts. The DPP's office that came into force in 2010, a serious office that has immense power, the creation of the Inspector General's office under the auspices of the Constitution of 2010, the creation of the judiciary pursuant to Article 165 and 159 of the Constitution gives the judiciary the independence that was not there in 2007. So really the Kenyans have put in place a machinery that will address these issues. So the question that now we are asking is, now that the International Criminal Court has pronounced itself, what are we waiting before we get the state machinery rolling to restore justice?
Which then would beg the question, Omari Okello, this morning, Is it really the ICC that has failed the victims, or have our systems failed the victims? Where do I ask this? A statement from the Attorney General states that we are now going to fully engage into compensation, full resettlement, and engaging a robust judiciary that will dispense justice. But weren't those things that were supposed to be happening concurrently with the ICC process, Okello?
Well, precisely. You remember the judgment that was delivered yesterday, the judges actually alluded to reparation to the victims. There is what they call the Victims Trust Fund that has been established by The Hague, by the ICC. And what they said is that they are waiting for some presentation, probably from the lawyer representing victims. And I think Nerito will be handling this. So I think there will be a session upon which they will now convince the judges or probably the registry and show how well the Victims Trust Fund can be utilized to at least compensate these victims. But you're right to say, and my brother has said it here, whatever happened falls within the purview of the Kenyan courts. And therefore, in order to wait for ICC to direct the Kenyan government to pay its own victims who are present here in the country, I think was expecting too much from the courts. Even though orders on costs would primarily be issued by a court of law. But, you know, as my brother Omari did say, those who burnt their neighbors' houses are known. Those who gouged their eyes are known, and they're living right here with us. The cases actually went to court, and many of them, immediately after the swearing in of the Grand Coalition government. But to date, we haven't had anything at all. The government has engaged in this ping-pong, flip-flopping issue of giving victims certain token to keep them in the camps, if you remember the ID camp issue. But that has not been enough. Again, it does not serve the interest of this nation to start resurrecting these issues that border on volatility. Because if you want to remind people, and I'm taking a cue from what happened in South Africa, during the apartheid period, blacks underwent very, very difficult moments. But Mandela rises into power and actually picks a white to be his deputy. What was the intent? Was to heal the nation. And even in Kenyan case, if we are going to go back to the court and subject those who probably committed these atrocities back to the judiciary for a judicial process to move full hog, I think we shall be inflicting wounds that have already healed. I don't think the country is willing to go that direction. The government keeps a database of all the victims, and I want to believe they are safe gathering dust in some shelves. The government ought to just come up with a decree that each and every person, because again, you cannot really compensate life. You cannot really compensate somebody who probably lost a business. But the government needs to come up with a uniform figure and say, yes, we sympathize with what happened. Those who went to the ICC are now free men. Let us move on as a nation, but this is what we are going to compensate you with. You are not going to get full compensation. I mean, the government cannot indemnify everybody for whatever they lost. But at least we need to appreciate as a nation that they lost their lives, they lost a business, they lost a revenue stream. Therefore, help them move from where they are. Because most of them, you go to the homes that they live in, they are in a dilapidated state. The kind of lifestyle that they lead is not pleasing to anybody. So they need to be restarted and jump-started so that they can move on.
It's so that they can move on. Let's get to the question of what even the government is calling restorative justice for the victims. Already there's a fund set aside, 10 billion Kenya shillings. But let's look at this issue versus the institutions that can probably, you know, see this kind of a thing move on. Huh? We've had a conversation about institutions in this country, and we've said something needs to happen with the judiciary. If this process is to kickstart, they just might be involved. The office of the DPP, people are saying that office needs a lot of reform. I mean, look at this country. Money is allocated to NYS, 791 million lost. 180 to the Youth Fund lost. Could 10 billion be allocated for restorative justice na pia hiyo iende?
You see, Sammy, one thing that Okello talks about, and we've talked it on Iron Politics for quite some time.
Yes.
One foreigner, Michael Joseph, the CEO of Safaricom, former, made a very serious utterance. He understudied the Kenyans and said, Kenyans have peculiar habits. Even me. Why do I agree with him? The ICC has convicted several Africans.
Yeah.
Nobody has ever raised an
Including
issue.
last week.
Even last week, they jailed Bemba for life.
Yes.
They gave another guy from Yugoslavia 40 years.
Yeah.
You've never had any noise.
Charles Lubanga.
But during Kenya's case, there was global noise, which tells you a Kenyan is not an easy guy. Right now, as I'm talking, people know that 10 billion has been set aside. Can you be able, with a lot of authenticity, identify who lost a cow, who lost land, who lost a house? Already, when people heard that there's compensation, everybody went to the camp and claimed, I was an owner here. It is a very serious issue. The Kenyans are not easy guys. We are a nation that takes advantage of people who have shed blood. I'm a lawyer. A matatu gets an accident. The matatu is licensed to carry 14 passengers. In the list of people in that vehicle for the purpose of insurance compensation, you get a list of 300. I was also inside. So the courts cannot really verify how these matatu Nissan carrying 14 passengers has 300 people claiming. To date, when the government tried to compensate the whole of Rift Valley, the whole of Nyanza region, the whole of Western region, the whole of Central, there were thousands and thousands. And I believe to date, immediately that was done, the whole of today night, people have moved to temporary camps, and they are saying, you know, we are waiting to be compensated. So really the institutions that will be given this to verify is a problem. These institutions are chaired and manned by Kenyans who have the same mindset that the money that we get, 10 billion, 8 is ours, we can give 2 to these guys. So the end result that it is going to be a fiasco. We need as a nation to really call for a national discourse to look whether we understand the values as provided for in Article 10 of the Constitution. Can we respect ourselves and say, really, those who suffered, this is their money? That's my fear.
Exactly, and even as Okello you come in, I believe now this process has brought in a very fundamental aspect that has been lost in the course of this entire debate. It's not about who goes to The Hague. It's not about the ICC. It's not about us versus the international community, but our systems within and how we relate with each other. Is it time, Okello, we had a very serious conversation about that very issue? How Kenyans relate with Kenyans?
Well, you have talked about 10 billion that has been set aside to restore these families in the name of restorative justice. I don't know whether that will be able to happen. But one thing that you must be aware of is that probably half of that money will go towards administrative costs. They will talk of buying Land Rovers and establishing centers for distribution. And at the end of the day, only half of that money will be available to be spent on the victims. That is why I said I want to believe that the government has a database, because if they don't, then the number will plummet. I mean, many, many people are going to come up claiming this money, including myself, if I have time.
You will.
Time is something that I don't have. Yeah, but nothing stops me from saying I was a victim.
Yes.
But again, every Kenyan was a victim.
Uh-huh.
Out of 1,300 people who died, you must have been related to one, either directly or indirectly. So they may end up spending this money on every Kenyan, including William Ruto and Uhuru Kenyatta, because they must have lost guys also. So a system must be designed. I want to again reiterate the fact that the government is already keeping names of these people somewhere. Otherwise, it will just be another ping-pong game being played on the Kenyan people. But it is crucial that now that the yoke of ICC is not settling on anyone's neck from the country Kenya, we need to now come back and carry out an introspection, paying attention to exactly what precipitated chaos of 2007, 2008. I'm very afraid that drumbeats of war have started to be played by various politicians. We got into the abyss as a result of political statements from reckless politicians. If the matter could have been handled differently, we may not have gone to the drains as we did in 2008. It is incumbent upon the same institutions that we lack faith in. You talk of National Cohesion and Integration Commission, a very toothless institution. You talk of the DPP's office, a revolving door. It is called Mr. Return File. Every time a file lands at the DPP, they take it back to the EACC for further investigation. And back again. So Kenyans have been made to become a revolving door of sorts. The IEBC, with all the credibility issues that have bedeviled its operations, I think must be addressed. The only
judiciary.
problem, and the judiciary with the 200 million and above that you have to pay in order to access justice. And you know, it has happened at the ICC. The narrative now is that ICC only targets low-hanging fruits and not the big fish. A similar thing that happens here. Justice is only dispensed when a poor man takes another poor person in court. Then you really expect the judge to go through the evidence and deliver justice. But the moment it is changed a little bit, the scales are tilted, in the sense that a rich guy takes a poor man to court, or a poor man takes a rich guy to court, you definitely know where the justice will end.
Yes.
So we also ought to address the gaps that exist within these independent institutions to also give us hope that whatever we have achieved as a nation, we have actually moved forward since 2008. A Luo can go to Nyeri, people from Nyeri can go to Kisumu, Kalenjins can settle in Kiambu. I mean, we have moved forward as a country. But then it is incumbent upon us as Kenyans, particularly paying credence to the roles played by independent institutions to address issue of a resurge or a relapse of a situation where the country would go back to where we were in 2008. The weaknesses that have been registered from IBC particularly and judiciary, because it is upon these two institutions that peace will prevail. And we have said it enough times here. That Kenyans deliberately refused to go to war in 2013 because they thought that Mutunga's team was going to deliver justice. At least send the country back to the ballot for a rerun. Look at what they did and look at what is now coming out. That justice is on sale and the highest bidder at the court or rather in the name of litigants would carry the day. So we must as a nation challenge these institutions. It lies on us, not on the international community. No foreigner would come here to help us correct our ills. We must do it ourselves because then you take a rich guy to the ICC, they will come back scot-free.
Which is actually, you know, it's literally what has happened with this ruling. Because when now everyone, the yoke is off their head, what more or less the international community is saying, fine, you said this is an issue that can attract domestic solutions.
Go with it.
Here you go. We want domestic solutions. And for the sake of the country, we do hope that indeed we shall get domestic solutions. Omari, there has been a certain part of this conversation that has been very consistent: non-cooperation. From the onset, non-cooperation. Bensouda complaining non-cooperation. Ebo Suji comes and with his team, Robert Fremer, even with a dissenting voice from Judge Herrera, that there has been a lot of witness interference and political meddling. With these three factors in play, non-cooperation, political interference, witness interference and political meddling, are we looking at any chances of re-prosecution in the future?
First and foremost, let us deal with the issue of non-cooperation. There is an allegation from the prosecution's office, the OTP's office, that the Kenyan government failed to cooperate. When the Attorney General, Professor Githu Muigai, my lecturer, stood at and addressed the ICC, he asked a very simple question. You are asking for mobile data, details of President Uhuru Kenyatta. At that time, there was no Safaricom. Data were, the Safaricom mobile phones were not registered.
We were not registering SIM cards.
So really, what are you asking?
Yes.
So what I'm saying is that the prosecutor was asking for what is not available. They are asking for bank accounts of President Uhuru Kenyatta and William Ruto. The question is, the Kenyan law does not allow. So the question that was there is that whatever they were asking, to them what they thought was supposed to be a cooperation was not based on any law. This country is not a banana country. The constitution was in place by that time, and the Kenyan law is supreme. So that is why I'm saying there was no aspect of non-cooperation. It was imagination, figment of imagination from the prosecution to demand that which they could not get or that which did not exist. When you talk about witness interference, one, the judgment, I wish we could have gotten the judgment. Who is alleged to have interfered with the witnesses? Is it Ocampo who interfered with the witnesses? Remember, William Ruto's case is based on a guy called Yebei who died. The prosecution is saying, this is our witness. Ruto is saying, this is my neighbor, this is my witness. You, Ocampo, and Bensouda have killed my witness. So between the two, who interfered with the witnesses? There's definitely, because of the evidence that has been produced. One, the civil society has been indicted to have interfered with the witnesses. Where was the civil society in 2007? They were in the side of fixing the people to go to the ICC. So in my view, I find that the question of the witness, interference with the witness, if indeed it is true, it is both sides. It is more criminal when government, in the form of the OTP, can interfere and can bribe witnesses. The OTP has nothing to lose. So really, in my own view, I find out that that is why the judges were so hard on the office of the prosecutor, that you, as the arm of government called the court, why could you go to interfere with the witnesses? Three, the other issue you raised about was
political meddling.
The political meddling. That one is very critical because you cannot avoid it. And I've always said there, is the ICC a criminal court? It's not. It is supposed to deal with political cases. The political environment under which the ICC operates, the prosecution and the courts ignored it. It was through a political process, alleged offenses were done, and therefore the crimes, the international war crimes, are crimes emanating from political power. The network that needs to be there is a network that will only be facilitated and survive through a political process. So the fact that the ICC ignored the political angle towards this case led to this case collapsing. So in my view, the judgment, after we read it as lawyers and dissect the issues that are there, is that the courts have properly identified 3 areas of reform of the ICC. 1, how to investigate. 2, how to avoid political pit traps. And lastly, how do you sustain a political charge to have a criminal element? Lastly, the objects of the ICC. The ICC is formed to keep peace. Number 1, could they have given another decision? Could they have sparked a major political problem and peace problem here? Definitely. So, based on that, the ICC has delivered within its objectives. But Sami and Okello, have you ever imagined one issue? 2013, we didn't go to the war. Okello has always said it, that we refused to go to the war because there was an animal somewhere called the ICC.
Monster, yeah.
Let us not be vague, let us go to the ICC. Everybody believed the ICC. When Ocampo, Kofi Annan was made, also people saying, oh, Kofi Annan to be the president of this country. When Ocampo came here, he was a celebrity. People laid hope. What will happen in 2017?
Yes,
that's a very critical question.
To add on that,
yeah.
As we said, the judges did talk about interference of witnesses to a greater length. It actually was captured in the final orders, that based on the witness interference and political meddling, it became untenable to really have this case proceed to the next stage. But, you know, we have 3 warrants of arrest on Kenyan heads.
Yes.
3 gentlemen who should be appearing there to answer onto those. And I want to believe that is where they brought that annexus, that there was indeed sufficient evidence to prove that there was witness interference. But again, you know, ICC has always paid attention to the politics around this country. You remember when President Uhuru Kenyatta and his deputy William Ruto were to coincidentally be in court at the same time. Uhuru actually went to a public rally in Ruiru and said over his dead body, he cannot be away when his deputy, otherwise Raila would be in charge. And the following day, ICC had to make that correction to say, no, well, we will drag your day. So that means they were paying a lot of attention here. And Usuji, enough times, drew a lot of inferences from political pronouncements from Kenya. So they were very much alive to everything that also happened outside the chambers, and particularly in this country. And all the statements sometimes bashing the ICC. So lots of political interferences they knew did exist, that therefore informed the degree of their judgments. And again, you talked about what
there
else?
was witness interference, there was political meddling, there was non-cooperation.
Oh, yeah, on the non-cooperation.
Yes.
Well, you know, the burden is on the prosecutor to prove. You don't go to court if you don't have evidence, and you don't expect the defense team to help make the case look stronger. It is the work of the defense team to trash every advance that you make towards them. So it was foolhardy, therefore, for Bensouda to now claim that there is non-cooperation in Kenya. She ought not to have presented that issue in court at the very outset if she didn't have credible evidence, if she still had wanted to wait for more evidence from the Kenyan government. Remember that Uhuru and Ruto went to ICC when they were not in power. Well, Uhuru was partially in power by virtue of being a deputy prime minister at the time. But of course, he still had 2 bosses ahead of him. At that particular time, it was very difficult for the OTP to access any information from government. But then Uhuru rode into power, and Bensouda now expected the guy in power to help her access documents that will incriminate him. That wasn't going to work.
And also the sovereignty question. You know, ICC was viewed as a foreign entity.
Right.
How dare you come and demand of us?
And finally, just in the same, the sovereignty. No country has powers with its police to crash into a different country and take whatever they want. That can never happen. The element, however small that country may be, like Benin, you can't just go there because you're a superpower. Therefore, you then torpedo the ship of many international conventions, including Geneva Convention. So that cannot basically work. So the burden was going to shift to the defense if the issue was going to move to the trial stage.
To the trial
It
stage.
had not gotten there.
Yeah.
And therefore, you did not really expect William Ruto and probably the president, our president Uhuru Kenyatta, to help strengthen
himself.
To strengthen
Here we are.
the OTP's case.
Technically.
Here we
Take
are.
me, yeah.
But
I'm missing jail.
yesterday, as I was watching the news break, as I was flipping through channels, and at one point I almost got confused. Ruto Sang acquitted. Ruto Sang's case collapses. Ruto Sang's case terminated.
Terminated, yeah.
So I got to wonder, is it what exactly, let's just lay it bare in terms of what is a collapse, what is termination, and what is acquittal.
The first thing the court said, there are two statements, that the trial was a mistrial. When we talk of a mistrial, what it means is that in the first case, the case was not supposed to be there. There was no trial that started because there was no procedures that were followed within the law. The evidence gathering was not within the law. So nothing really was before the judges. That is the first thing they said, that it was a mistrial. Based on that this was a mistrial, because it was not a trial, they terminated and vacated and discharged the people. So that is what mistrial means. When you talk about acquittal, acquittal comes after all the case has been properly filed, proper procedures of gathering evidence have been brought, proper procedures have been followed during the trial process, then the court makes a determination that we have heard everything, we have put you on your defense, there is nothing to convict you. You are acquitted.
You're acquitted.
Go home. In an acquittal, you cannot be tried again. It is called a principle of double jeopardy. You can't be tried again. But the government, but the state can appeal against an acquittal. Free, on the question you raised about which other term?
Collapse.
Collapse. Collapsing is similarly, it's not a legal term. It is an English term saying it is no longer there. The case that was there, due to the weight or due to the non-sufficiency of matters, has died. Remember, I did say here sometime when I was with you that the case has already died. We are only waiting for the mortician, the mortuary attendant, to declare that the case is dead. And he did it yesterday. So that is the position that is saying that a dead case has collapsed. So, but there is one issue that the court said. One, there's leave for the prosecution to appeal. They can appeal through to the appeals chamber. But the same appeals chamber is the one that threw out
The recanted
the
evidence.
recanted evidence. Are you likely to face the same judges who have already said, my friend, I teach a student of law at Catholic University. The first 2 weeks of law, you are taught that you cannot use recanted evidence. Every lawyer, everybody knows that.
It's basic
so I
practice.
don't think
She will
opt
appeal
to that. Two, the court said that in case the prosecution gets some evidence, they can revive the matter.
Exactly.
Remember, the president's case is not closed. They withdrew the matter, waiting for more evidence. Ruto's case can be restarted. It can be restarted when Ruto is 140 years to come. It can be started when the president is not in power. The question of non-cooperation, and this is a dynamite I'm releasing. Is it that the ICC will wait when a regime that is friendly to it
comes into power,
when it gets that information? Is it going to determine now that Jubilee, and by extension William Ruto and President Kenyatta will make sure for 1,000 years.
Yeah, well,
Two very key questions for you, Okello, because we've got to wind up. Number one, there were those gentlemen that had arrest warrants on their necks because of interfering with witnesses. Does their case or does their situation still persist? And the next question centers around, you know, what Omari is saying, that they could wait for a time where a regime is more friendly to them. If Kenya pursues a withdrawal, shall we still fall victim to that kind of a situation?
well, lawyers would commonly ask the court to grant them leave to appeal. On this one, on their own motion, we call it suo motu in law. Suo motu, they just allowed them to appeal, you know, because they said without prejudice also to the presumption of innocence to the suspects. So on that alone, I think there can be a cause to worry. But there has been a tradition right from the time our matters went before the ICC, that even when the OTP has lost into any matter, they never make any appeal. So I want to believe it is dead and dead at that stage. They took cognizance.
We trust tradition.
Yes, I trust tradition.
We also should trust tradition as a
Well,
country.
we should to a degree.
Isn't that too risky?
Well, in law they call it, you know, deriving from authorities.
Yes.
So you can look at an authority and relate it to another case. So I don't think Bensouda would go that route. And the court itself has taken cognizance of interference and political meddling. It will be rife when we hear that she's going to appeal. So I know that they're forgetting about that. But you asked about the 3 people who have warrants of arrest on their heads. Well, there is evidence that there was a lot of interference. From the Kenyan perspective. And Kenyans have also tried to put roadblocks on the appearance of these interferees, so to speak, at the ICC. So I don't think that cooperation will be there. Kenya will still hold on to those people here and say, even if there is credible evidence, we can still use our mechanisms to handle them through our judicial process in this country.
So we go domestic.
So we will go domestic. I don't think Kenya will be in a position.
We won't arrest them and take them.
Oh, no, we will never do that.
We are done with that
Otherwise,
process.
Gishuru and Okemu will be in just.
That's true. Jared Okello, thank you so much. Dunstan Omari, asante sana. Today we were dealing with the ICC aftermath, as is the caption on your screen. But come Monday, Iron Politics, we will deal with all the siasa. Yote tutachapa hapa Monday. Today we just needed to understand what the ruling came with from the ICC. And of course, come Monday, we shall be looking at critical questions. Key among them, is it a blessing or a curse for the Deputy President now that he's free? Is he weaker? Is he stronger? What's the fate of the Jubilee, party and the merging and everything else? All that will be dealt with on Monday. But for now, thank you for watching. Have a great day. God bless you all. My name is Samuel Njoroge. Tupatane kesho.